is the Madiga community, Dalits from Andhra Pradesh, Telangana, and Karnataka. Once labeled untouchables, they remain among the most marginalized even today. Despite being a scheduled caste, the benefits of reservation have barely reached them. They organize themselves under the Madiga Reservation Porata Samiti, demanding sub-categorization for their upliftment. And there have been similar demands from many other communities such as the Valmikis and Mazhabi Sikhs in Punjab. And in 2024, the Supreme Court finally upheld their demand, ruling that sub-categorization of scheduled castes is constitutional. Following this judgment, Telangana has now become the first Indian state to sub-categorize reservations within scheduled castes. Let us understand the issue of sub-categorization and its evolution through judicial proceedings, whether it will actually promote social equality or lead to social divisiveness. Sub-categorization is essentially a quota within quota model, which refers to dividing the scheduled caste quota into smaller targeted segments. The demand of sub-categorization is rooted in the fact that not all scheduled castes have been benefited equally from reservation. Over time, some communities have seen considerable socio-economic upliftment, while others remain largely outside the formal economy, education system, and public employment. Historically, states in India like Punjab and Andhra Pradesh attempted to introduce sub-categorization for the scheduled caste by passing laws. However, in 2004, the Supreme Court in the E.V. Chinnaya vs. State of Andhra Pradesh case struck down these laws and ruled it as unconstitutional. The Supreme Court ruled that scheduled castes form a single, indivisible class under Article 341, and any such move would violate Article 14, as it would treat equals unequally within a constitutionally recognized category. But in 2024, in the state of Punjab vs. Davinder Singh, the matter returned to the Supreme Court again, and given the constitutional complexity, it was referred to a 7-judge constitution bench. In 2024, the court delivered a landmark 6-1 verdict overturning the previous E.V. Chinnaya judgment. It ruled that sub-categorization within scheduled castes is constitutional provided it's backed by empirical data. The court emphasized 2 key principles. Sub-categorization is valid if data shows certain scheduled caste groups are inadequately represented in jobs, education, or governance. Ignoring such internal disparities could itself violate Article 14 because treating unequals equally creates deeper injustice. Chief Justice D.Y. Chandrachud stressed the doctrine of substantive equality. This principle recognizes that different communities face different degrees of historical injustice, and that genuine equality can only be achieved by addressing these differences and not ignoring them. This marks a significant shift in India's affirmative action framework, recognizing that even within the marginalized, layers of inequality persist. However, several challenges may arise in implementing sub-categorization. Collecting reliable and up-to-date data on different subcastes requires extensive surveys, which can be both resource-intensive and time-consuming. States also face the complex task of defining appropriate criteria, such as levels of education, income, or public employment, to measure relative backwardness. Moreover, there is a risk that sub-categorization could be influenced by political considerations, potentially turning a tool of social justice into one of electoral strategy. Even though implementation of sub-categorization faces plethora of challenges, it has enunciated a fresh perspective in India's political discourse to address historical injustices.